believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
Hello everyone. Welcome back to today's video. We've got a truly unusual case involving a man named Kevin Dwayne Craft, who has taken his situation all the way to the Michigan Court of Appeals. But this isn't your typical legal fight about rights or travel. He's challenging the state's authority over his responsibilities as a father. Instead of following standard legal obligations, he's arguing that the state has no say in making him care for his children. The case is surprising, frustrating, and hard to believe all at once. So, let's dive in and see exactly how this played out.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
Wait a second. You're the one who brought this case all the way to the Michigan Court of Appeals, and now you're questioning whether they even have authority. To clarify, the court's jurisdiction over you is established both personally and by law. It's clearly laid out in the United States Constitution as well as the Michigan State Constitution. This means the court has the legal right to hear your case and make decisions regarding your obligations. Ignoring these rules won't change the fact that the law applies, no matter how you try to argue it. Understanding this is key before moving forward with any legal challenge.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter.
But is that really the case? In Haynes versus Kirnar, the courts made it clear that a defendant claiming civil rights violations must be given a chance to provide evidence before their case can be dismissed. You can't simply ignore a claim without reviewing the facts. Of course, many of the motions in this case were likely dismissed, but that doesn't automatically make it a civil rights issue. It seems there was some confusion on his part, thinking his personal situation equated to a true civil rights violation. Understanding the difference between legal obligations and rights is crucial in cases like this.
In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 40 agency to give away my biological and genetic material.
So that's really what this is about. You're trying to avoid taking responsibility for your children and paying child support, so you're turning to unusual legal arguments to justify it. Cases like this show how far some people will go to escape their obligations, even when the law clearly requires them to provide support. It's important to understand that the courts are focused on ensuring the welfare of the children first and foremost.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, with this a constitutional court. The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
Well, here's the first issue. Michigan Compiled Laws Act 205, also called the Parenting Act, clearly gives the state the authority to collect DNA in situations like this. The law outlines exactly how DNA can be obtained and what happens if someone refuses to cooperate. This ensures that parents are held accountable for their responsibilities, especially when it comes to child support and custody. Ignoring these rules can lead to serious legal consequences, so the state takes this very seriously. Understanding these procedures is key before trying to challenge them.
I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers. 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Let me guess, your first reaction was panic, realizing this could end up costing you more money. And despite trying to avoid it, the DNA test would still prove that you are indeed the father. Moments like this show how people sometimes focus on the financial consequences instead of accepting their responsibilities. The law is designed to protect the children first, and avoiding the truth rarely works in anyone's favor.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary and I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Right? No, you're not a corporation. Honestly, this might just be a strong contender for the most unnecessary information of the day award. Sometimes people bring up details that don't change the situation at all, and it just adds to the confusion. Moments like this can be frustrating, but they also show how important it is to focus on what actually matters in a case.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I found. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation.
What happens when you pay child support to the state? The money goes to the guardian of the child, not the state itself. The state isn't collecting someone else's debt for a profit. It acts as a mediator to make sure the child receives the support they are legally owed. Its job is to ensure that parents fulfill their responsibilities and that the children get the care and resources they need. Understanding this can help avoid a lot of confusion about how child support actually works.
I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more child support. The main argument I have here, and for you guys, is full disclosure. It seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out
yes.
of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case, and then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20
I
seconds.
can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
I'm going to assume that both the short and long answers are likely the same. All right, that wraps up today's video. As the judge mentioned, a decision should be released in a few weeks. And as long as it's public information, I'll be there to share the outcome, including the sovereign citizen's loss. If you enjoyed this video, please hit the like button. If it wasn't for you, the dislike button is fine too. Don't forget to leave a comment below. I love reading your thoughts, and subscribe with notifications on so you never miss any of my future content.